So certainly that was based on public perception that helped bring down the plan. Other factors included the fact that one of the existing justices, Owen Roberts, actually changed his mind. He had been consistently voting against Congress's broad enactments upholding the New Deal. He changed his plan, apparently, according to conference notes from the court, actually before FDR came out with its court packing plan. Maybe he saw the writing on the wall, who knows? There's a lot of speculation about that. So the court as an entity is certainly said to have a lot of power, but its power depends on perception, and perception depends in part on the people who staff the court, right? Because we don't think of the court as an abstract entity, we think of the court in terms of the people who currently populate it. And that brings us to the second topic, the selection of justices. Here again, the U.S. Constitution speaks to the issue. And it states in Article 2, Section 2, the President, by and with the advice and consent of the Senate, shall appoint judges of the Supreme Court. So we have two key players in the selection process, the President and the Senate. And again, it's significant to note what the Constitution does not say. It does not prescribe any eligibility requirement for Supreme Court justices, not even a law degree. Nor does the law say anything about what approach the U.S. Senate should take in deciding whether to consent to an appointment. In the absence of guidance, both presidents and the Senate have taken different approaches to their role. I'll start by talking about the president's approach. Now, scholar David O'Brien has proposed that there are basically three models of presidential appointment processes for U.S. Supreme Court justices. And I mention these three models not because I necessarily agree with Professor O'Brien's analysis, but I think they do provide interesting food for thought. So one model he calls the classic democratic model, in which presidents use the selection process to reward friends and party faithfuls. He says that this model was favored by Presidents Franklin Roosevelt, Harry Truman, John Kennedy, and Lyndon Johnson. A second model that Professor O'Brien identifies, he calls the bipartisan approach, which he attributes to Presidents Eisenhower, Gerald Ford, Bill Clinton, and Barack Obama. These presidents, he said, emphasized competence and didn't apply any sort of rigid ideological litmus tests. O'Brien's third model he calls the Republican ideological judicial selection process, a model that he attributes to Presidents Richard Nixon, Ronald Reagan, and both George Bushes. And I dare say that he would also include President Trump in this camp. This model is self-explanatory. It is based on making selections to the court that are designed to select a nominee who will follow the ideological views of the president who appoints him or her. Now, I think it's interesting to note that implicit in O'Brien's theory of these three different models is that none of them focuses exclusively or even primarily on merit, right? Even the bipartisan approach that some presidents have used were often dictated largely by political realities. President Gerald Ford is a good example of this. President Ford, a Republican, appointed John Paul Stevens, who, although a moderate Republican, came to be considered a very liberal member of the court. But Ford was influenced in significant part by the perception that his predecessor, and now disgraced predecessor, Richard Nixon, was highly politicized in his approach to making Supreme Court justices. So part of President Ford's attempt to heal the nation and resolve some of the divisiveness that characterized the Nixon era was a determination to take a bipartisan approach to appointing justices. Now, so far we've talked about one of the two key players in the selection process, the President. The Senate, of course, has come to play a decisive role, extremely important, but this wasn't always the case. In early days, the Senate very often consented pretty much routinely to the president's selections without very much hoopla. President George Washington named his six justices for the U.S. Supreme Court's initial membership in a letter to the Senate. He sent it over. 2 days later, the Senate approved Washington's selection by a voice vote. All of the 6 people were Washington's friends and political allies, so that kind of set the tone for one of the models of the selection process. But the way was not always so easy. The Senate actually, from very early days, did take a role and said no when it felt it needed to. Indeed, President George Washington himself was unsuccessful in getting John Rutledge named to be Chief Justice of the Supreme Court. The rejection was largely political. It was based on Rutledge's opposition to the recently negotiated Jay Treaty of 1795, which was a peace treaty with Britain. Then, following Washington, the Senate was relatively acquiescent in the president's selection of justices up until beginning about 1824, which was when John Quincy Adams was elected president by the House of Representatives. You may remember that his election was thrown into the House of Representatives. Speaking of another divisive time, and of course, 1824 marked the beginning of a very divisive era that would ultimately culminate in the Civil War. Between 1824 and the Civil War, presidents made a total of 30 nominations to the U.S. Supreme Court, only 16 of which, a little over 50%, were confirmed. And this just illustrates the fact that we've had other periods of divisiveness. To the extent that people get discouraged or worried about eras of divisiveness, I think one can take hope from history. There probably have been times, although it doesn't always feel like it, that are more divided than they are today. So after the Civil War, again, the Senate largely took a back seat and acquiesced in the president's selections. Just to mention some aspects of the modern era, components of the modern era of the Senate's role in the selection process. The first time that the Senate held public hearings on a Supreme Court nominee was in 1916, when the Senate Judiciary Committee held hearings on the nomination of Boston attorney Louis Brandeis. Now we have an expert on Justice Brandeis in the audience here with my friend and colleague Don Burnett. But some of the opposition to Brandeis was likely because he was Jewish. But he also was controversial because of his progressive political views. And in particular, his view that courts should make decisions informed partly by scientific and sociological data. The first time a nominee personally appeared to testify before the Senate Judiciary Committee was in 1925, when Harlan Fiske Stone testified at a private hearing before the committee. It does bear mentioning that the committee on occasion has held private hearings, and one has to wonder, I'm flashing forward a little bit, whether it would have been tolerable, acceptable, preferable for some of the portions of the Kavanaugh hearing that have been conducted in private. Nonetheless, Harlan Fiske Stone testified to the Senate because of his involvement with investigating the Teapot Dome affair. So politics once again raised its ugly head. Beginning in about 1932, public hearings became essentially a regular feature. Now, probably the modern era marking the Senate's current role in the nomination process that was characterized by divisiveness would have to be traced to President Reagan's nomination of Judge Robert Bork in 1987. And I'm glad to see, just based on looking at the colored people's hair in here, that there are people who, like me, remember that time. Bork was controversial for a number of reasons, including his firing of Archibald Cox, the special prosecutor for the Watergate investigation. And a couple of people resigned before taking President Nixon's order to fire Cox, but Justice Bork was the man who pulled the trigger. It's also Justice Bork's ultimately unsuccessful nomination prompted a speech by Ted Kennedy I wonder how many of you remember Robert Bork's America. Anybody remember that one?